I will now call the third case on the morning docket. It's three case numbers of 117903, 904, 905, and 906. Eagle Med LLC versus Travelers Insurance. And while council approach, I will take a moment to introduce Judge Mike Malone, who is now on the bench with us. As I mentioned earlier, Judge Malone had been serving as a senior judge assigned to this court, recently retired from that, but so do I. Today is sitting by designation. Thank you, Judge Malone.
Thank you.
Counsel?
May it please the court, and good morning. I'm William Townsley. I'm appearing today with my partner, Nathaniel Martins. We represent Travelers Insurance. Madam Chief Justice, I'd request 3 minutes for rebuttal.
3 minutes is granted.
Thank you. By way of procedural history, let me explain how our case came before the court today. This is a workers' compensation fee dispute regarding the fees or medical costs charged by air ambulances. The dispute concerns the interplay between the Federal Airline Deregulation Act of 1978, which bars or preempts intervention in rate setting by states, and how it conflicts with the Kansas Workers' Compensation Act that has a fee schedule requiring reasonable fees to promote cost containment. Specifically here, we're dealing with 4 cases that occurred in 2013. These all involved injured workers who were injured in western Kansas and then flown by either a helicopter or an airplane to Wichita. The average cost of those flights was about $30,000. In each of those cases, Travelers Insurance was the insurance carrier for the employer. Travelers offered to pay for those fees pursuant to a federal fee schedule, and the offer was about $6,500 per flight. Eagle Med declined that offer and filed a request for a fee dispute hearing in the Division of Workers' Compensation. The Department of Labor appointed an administrative law judge who initially determined that the McCarran-Ferguson Act, which allows for reverse preemption or state intervention in business and insurance cases, applied to this matter. Both parties then appealed to the Workers' Compensation Appeals Board, a board of 5 fact finders who deal with the administrative claims from the Workers' Compensation Division. The Workers' Compensation Appeals Board disagreed with the administrative law judge, agreed with the parties that the ADA preemption applied here, remanded it to the administrative law judge, who then determined that he did not have jurisdiction to decide the case and ordered payment or full payment of the bills. At this point, Travelers appealed to the Workers' Compensation Appeals Board. The Appeals Board affirmed the order of the administrative law judge below that they did not have authority to address the fees and ordered them paid. There was a motion for reconsideration. Following that, there was an appeal to the Court of Appeals by Travelers, and the appeal was twofold in that the board had erred, that there was jurisdiction to determine the case, and that the payment should not be ordered. The board eventually, or the Court of Appeals, affirmed and reversed. It affirmed that there was an authority to decide the case. That reversed the order of payment. Both parties appealed. That's how we're here today.
Is there ever any argument that because Eagle Med voluntarily went into the workers' comp universe in order to enforce to collect its money, that it was then subject to the rules of workers' comp and should have to live or die by the sword that they pulled out of their uniform?
Well, Justice Biles, we would agree from our perspective that when you're in the realm of workers' compensation, that some of those ramifications or some of the basis for the Workers' Compensation Act should apply here. And that's the whole issue. The issue before you is whether the Court of Appeal erred in holding that federal preemption prohibited the Division of Workers' Compensation from making any review of the exorbitant charges that Eagle Med seeks to have enforced through the Kansas Workers' Compensation Act. And we ask the court to reverse and vacate the Court of Appeals opinion and direct the division to limit the
And
charges.
I guess I'm just trying to get at whether there was an argument, and I'm not sure if it would be categorized as a waiver of the protections that it seems to have from Congress.
And I don't know that would be accurate, Judge, and I think that both parties here have agreed that the Airline Deregulation Act of 1978 applies to this. And that's the...
Then why even show up, and I mean, why try to pursue your client in workers' comp rather than just running to the courthouse?
Well, and I think that's the question here is, and that's really the underlying issue here. The conduct underlying here is the fundamental question for the court. Should Eagle Med be allowed to circumvent the regulations that ensure fair billing practices to Kansas employers? And should their scheme be allowed then to take advantage of that? The obvious answer should be no. This isn't about specifically life-saving air ambulance services. This is more about a loophole created by the Act and the ADA. And the ADA, by way of history, it was intended to dismantle the hub systems used by airlines. And the idea was to promote competition between airlines, and the way they did that was not to allow any state intervention which would affect that airline travel. Air ambulances were included as air carriers, but clearly there's no competition there. In fact, over the time as things have developed, initially air ambulances were owned by hospitals, and they were almost more of a loss leader for hospitals, a public service. They would fly people in, and then there would be the back-end services provided by hospitals. In 2002, that all changed, and private companies began getting into the market. In fact, the number of carriers increased, but the cost increased. It was just the opposite of the intended purpose. So what we have now are consortiums, large consortiums, billion-dollar consortiums that own air ambulances, and it's hedge funds and equity funds that are purchasing air ambulances, and it's because they can charge whatever they want under this ADA preemption. And there is no reasonable tie to plug their fees or their charges into a comparable system such as the federal fee schedule and Medicare. And for example, if we have three individuals...
So why isn't the cure for this not us, but some legislation either from Congress or from states?
Well, I think it has to be federal legislation.
Right,
I think,
of course it would. So in Congress,
Right.
Why isn't that the cure? Why are we stuck with this?
Well, and that's our position, is that you shouldn't be. And of course, the issue here is Eagle Med is asking you to enforce and order us to pay those fees, and we don't think you're the remedy for that. Again, if I give an example, if we have three individuals in Hayes and somebody has a heart attack, they're flown to Wichita, that's going to be a Medicare flight, it's going to be about $10,000. If you have somebody in a motor vehicle accident in Hayes, they're going to be flown to Wichita, that's going to be covered by PIP benefits from automobile insurance or Blue Cross Blue Shield, who will pay a portion of that $60,000 bill, and there'll be a remainder left for that injured individual that Eagle Med may or may discount. And then there's workers' compensation. The injured worker who falls at work, who's flown from Hayes to Wichita, that's a bill of $60,000. There's no discounts. That's what's billed across. It's hard to justify this $10,000 for somebody getting the exact same flight under a Medicare federal fee schedule as compared to a workers' compensation claim in Kansas.
I don't think there's any, we understand that you're trying to fight federally sanctioned air pirates, you know. But I think where we're stuck is with the so what. Right. I mean, you know, it seems like your fight is with Congress.
Exactly.
And or the Federal Department of Transportation. I'm not sure, you know, I don't quite understand where your remedy lies for the policy issues you're talking about, but I don't think they're here.
No, and I agree with that, Judge. I think that's Your Honor, the remedy has to come through Congress. Department of Transportation now has that oversight.
Well, what are you asking us to do then, if you agree that you don't have a remedy here?
Well, what I'm asking you to do is to reverse the decision of the Court of Appeals, and because we believe that there should be some oversight from the Kansas Workers' Compensation Act, and it's not applying a state-based remedy, but there should be some determination of reasonableness. And we look, for example...
Can you help me understand how that's consistent with what it seemed like you just admitted
Well,
to Justice Biles a second ago, which is we're preempted?
Yeah, and I guess, Justice Stegall, the analogy I would have is, for example, in the school funding cases, this court sat and didn't set an amount of funding for the legislature, but you looked at sufficiency issues, and ultimately the legislature made its decision. Here, I think there should be some mechanism for us to determine why the system for Eagle Med is being the burden is placed on employers in Kansas. Workers' compensation in Kansas has insurance carriers, but it's billed back to the employers. And even more to the point, like the amicus of the Kansas Livestock Association, that is a group of employers that now has $400,000 worth of bills. There should be some reason to determine, we should be able to look and see why a workers' compensation bill is $60,000 and the average bill today is $65,000. We're talking about 2013 bills here. There should be some way to understand how this pricing scheme gouges employers in Kansas.
Let me ask you a hypothetical, which it's fine if you don't know the answer. Would it offend the Airline Deregulation Act for the Kansas legislature to simply carve air ambulance fees out from underneath the workers' compensation scheme?
Well, and a good question, and I think that in part that's what Eagle Med is asking the court to do, is to use the 44-574 to revise the statute here.
Well, I guess what I'm asking more directly is, could you have a remedy for these policy disagreements you have at the Kansas legislature as opposed to with Congress?
I think, Justice, what you're saying is if the Kansas legislature said we will not touch air ambulances at all, I think you can do that. I think what the preemption is that the Kansas legislature can enact legislation that impacts rates,
Right.
routes, services.
So Kansas, as I understand it, the Workers' Compensation Act permits the recovery of these fees.
True.
But the Workers' Compensation Act imposes some, I'll just say, reasonableness requirement.
That's true.
And the argument is that the ADA preempts that reasonableness requirement.
That's
But my
true.
question is, couldn't Kansas just simply say that these fees are not recoverable under the Workers' Compensation Act?
Well, and probably. And whether or not our legislature does that, I don't know.
But that would at least create an additional remedy for Kansas businesses that you're arguing are being harmed.
And I am arguing they're being harmed because I believe they are. And that's an approach. I don't know how that solves our problem. And I think that goes back to what Justice Biles said. It's got to be a federal remedy at some point.
Well, wouldn't that close the loophole that you're complaining about?
That if we just said that we have no regulation regarding air ambulances.
No, it just they would have to find some other legal claim to recover the fees. They couldn't use the workers' compensation scheme.
Yeah, and maybe that works, Jess. I don't know. That would certainly resolve the workers' compensation component of it and the dispute regarding the fee schedule.
Well, wouldn't that require, I take it that first off, neither the employer nor its insurer is part of the decision on transporting this patient from one hospital to the other,
Absolutely, that's right.
as opposed to in other aspects of comp, the employer has some say about the extent in the medical care.
Right.
So, and in these instances, So that's a decision by the treating doctor on transporting the patient, I assume. And does the doctor have alternatives to this air carrier in Kansas, or is there only one?
No, there's more than one, and I don't know that how their division of territories is set up, and oftentimes I don't know that they would have that choice.
But you're saying that it doesn't matter that there seems to be no price competition in this market.
Oh, there's none,
Right.
and worse, it's the price is what they say it is.
Why is there no price competition?
In the air ambulance world, it doesn't exist. And again, the competition in theory that should drive lower
Why?
prices.
Do you have a theory as to why there's no price competition?
Well, in part, it's because of why we're here today. This loophole for
It's because of-
ambulances being air carriers.
It's because the provider has no incentive
Right.
to offer their services at a lower fee because of the workers' compensation scheme. Right?
Well, that's absolutely right. And it's more to the point, they can set the fee wherever they want because they can. And
But
those costs go up.
presumably, if that loophole was closed, again, as a matter of state law, wouldn't competitive principles kick in at that point?
And I don't know, Justice. And-
Well, wouldn't that in that scenario, wouldn't if the carrier and the employer are out of the picture, then really it would be like any other medical claim where a person has or does not have insurance. There winds up being a civil suit to collect against the patient. Is that correct?
Right.
And then I suppose the patient can come in and defend by saying this is not a reasonable customary charge, or some argument about that based upon comparing this to, say, the Medicare schedule. And if the court bought that maybe you might be required to come in. It would be a backdoor getting back to the medical to the Medicare standard. But if the trial court doesn't buy that, then then the whole purpose of work comp has kind of been defeated, hasn't it? If an injured worker gets stuck with the bill for part of his payment, and
I
mean, the whole system breaks down, doesn't it?
Yeah, Judge Mencken, I agree with that, and that's probably the problem I have with Justice Stiegel's question is we carve it out, but then you've got this injured worker on an island, and then how do we reconcile all that? And it doesn't change the fact that the ADA preemption's out there anyway. So again, we believe that there has to be a mechanism here for the Kansas Workers' Compensation Act to have some sort of ability to analyze, even if it's pursuant to federal substantive terms, to figure out why we have.
How do you get there, though?
I don't. It's tough, Jess. I mean,
You're
it's
just
that's
saying
the
you don't know. You want us to
well.
make up a reason.
Well,
why
but
you-
isn't that worker on the same island if he falls on the sidewalk instead of inside the plant?
Oh, absolutely. No, that's right. And again, that's the whole issue here is that we've got these pricing schemes that's all over the place. Individuals, by story, I know that individuals have had air ambulance flights and then have had to declare bankruptcy because they couldn't pay for it. And so these remedies are hard. There isn't, as far as I can see, a clear path here. And ultimately, if there isn't a remedy to be provided here, then we ask that you affirm the Court of Appeals, and if we don't have jurisdiction to make any assessment, and this is a case where we haven't had a hearing. I mean, there's never been a hearing. I can't conduct discovery. I mean, these are questions we'd like to have answered, but we haven't gone past that point yet. So,
Well, if there's no jurisdiction, arguably, then you have no responsibility, right?
well, that's our position, is that if there's no jurisdiction to deal with this within the division or in the state of Kansas, then there should be jurisdiction to say, travelers, you pay all these bills.
So go back to Justice Bow's question, then you just, the air ambulance resolves it in court, and they sue the patient, the harmed worker?
Well, and that's one approach. I mean, that's your remedy. Is there are the court system, state or federal, and
On a quantum merit basis? Because there's no contract, is there?
Well, no, there's not. It's an adhesion contract. Again, neither do the worker typically, or definitely the insurance carriers have no idea, who's going to fly when and where. It's after the fact you get the big bill.
Right.
So
There's the cost. I mean, just getting to
Judge Malone's question, ultimately who bears the cost?
Yeah, and again, that's our challenge here. And ultimately, again, whether that comes as Eagle Med sues the injured worker, third parties in an insurance carrier, or sues the insurance carrier for the deficit. I mean, those are things that would sort out in courts, and I think again that's the forum for solving that remedy.
Counsel, you would agree, wouldn't you, that the Workers' Compensation Act provides jurisdiction to Kansas to enforce those bills, payment of those bills, right?
Well, under the fee schedule, you enforce those bills if they're reasonable, usual, and customary, if they're intended to promote cost
Right.
containment.
And what's arguably preempted by federal law is just the portion that relates to price, to the amount of the bill.
Well, that would
But
be
the
right.
ability of the of Kansas, of the Workers' Compensation Board and courts to enforce the judgment isn't preempted, is it?
Well, and I guess that's where the question here, do we have a judgment? We have a bill, and then does it fit within those parameters of reasonable, usual, and
But
customary?
assume with me that that portion of the Workers' Compensation Act is preempted. Why don't you have to pay then? Is the
Well, and
question.
again, if there's an order in place, if you've severed the statute to accommodate that, then that's going to be a difficult position for an insurance carrier under the act, if the act has been followed through to that end. So
I want to make sure I understand something, because I thought I did, and then with the discussion I'm confused. Under the Workers' Comp Act, the injured employee gets to look to the employer to pay the medical bills for the treatment
True.
of the injury, which includes air ambulance, regardless of whether it's, I mean, the employee has given up a lot of legal rights in order to have whatever protection the Workers' Comp Act gives that employee. But one of them is that they're not responsible, the employer's responsible, and the employer, in order to protect against those costs, has bought insurance from travelers. So you're always going to be on the hook. This isn't a situation where these air ambulance services just sue the worker, the injured worker, because you have to be there, right?
That's true, unless we have a self-insured employer or an insurance trust, where then there's no insurance carrier. You've got a Kansas
Well, but the
employee.
employee has somewhere to look.
Sure.
That's all I'm getting at.
Yeah, no, and I agree with that.
And for the purposes of this case, Travelers is the one that has insured these employers against these expenses.
Right. No, I agree with that.
Okay.
And again, in response, I think I agree with that the insurance carrier is liable here. That's the whole point of workers' compensation. It's the exorbitant and this disparate price scenario that's so problematic to have either this court or a workers' compensation court buy into this is what we're going to do. We're going to support this, and we believe that conduct's wrong. So,
And then
again,
just one other thing I want to get in my head here is, let's assume we were to rule that there's no jurisdiction and go with the Court of Appeals view that y'all are just on your own to go figure it out next. Do I understand that if there's a lawsuit filed on this claim, state or federal court, that the argument becomes whether you're even allowed to challenge the reasonableness of what an issue in litigation would be, whether you're even allowed under federal principles to be able to challenge the reasonableness of the fee?
well, clearly
They would
that's-
say you're just stuck.
Yeah,
Unless
clearly-
you go to the Department of Transportation.
Right, no, that's clearly Eagle Med's position is
Okay.
that there is no challenge, and we believe that that's not right.
Well, that's the way I read some of the cases I was looking at where there had been, but I just wanted to.
All right. Any other questions?
Thank you, counsel.
May it please the court, Your Honors, my name is Joshua Fox, and I'm here on behalf of Eagle Med. I believe the question before the court is, what does preemption mean for the Kansas Workers' Compensation Act? And if this court follows the Court of Appeals opinion, it turns the Kansas Workers' Compensation Act on its head. If this court follows Traveler's reasoning, either for jurisdiction or for severability, it again turns the Kansas Workers' Compensation Act on its head. And this is the reason why. If the Kansas Workers' Compensation Act can't order payment, under the Kansas Workers' Compensation Act, the Division of Workers' Compensation cannot order payment, then our only remedy is what we would traditionally do outside of workers' compensation, is we would look to the patient first. And then the patient would look for third parties that would be responsible. Here, that would likely be the employer. That would mean the quid pro quo that this court has talked about on a number of occasions would be gone. The worker would be responsible, the employer would be subject to tort liability. That is why, in the Cox opinion, which is in the 10th Circuit, exact same set of facts. Let me back up and let me tell you a little history about that case. That case started in the Wyoming Workers' Compensation Division, just like this one did. In the middle of that, the parties to that case said, hey, let's figure out this preemption, but let's move over to federal court to do it. They had a federal district court judge decide preemption. That went up to the 10th Circuit. The 10th Circuit said it is preempted, no doubt, but under rules of comedy and actually some complicated pieces of Ex parte Young, we want to send this back down to the state to determine how you do severability under Wyoming severability law. And right after that, in that very same case that started in Wyoming, the Air Methods opinion, which we provided a supplemental briefing to this court, and in the supplemental briefing at the end to this court, the Wyoming Supreme Court did exactly the severability analysis that we believe this court should have to do, and that this court would do under Kansas law. In all material respects, Kansas severability principles, Wyoming severability principles are the same. In all material respects, the Wyoming Workers' Compensation Act and the Kansas Workers' Compensation Act are the same. We believe that's the analysis this court should do. There's one other alternative that this court doesn't have to do that same analysis, and that is that all four of these transports fall under the 2012 fee schedule. This is a different way that the court can get to the same remedy. And that is that 2012 fee schedule, the director who wrote it recognized that the ADA preempted and included in that language that it's usual and customary charges pursuant to the ADA. And if you look at 44.510I, usual and customary charges are also used in the statute. Underneath it, or right before it, the modifying language says the beneficiary's usual and customary charges. So we believe actually for these four transports, the fee schedule was fine. And that the Division of Workers' Compensation.
What is the usual customary under the ADA? Isn't it just the market?
So the ADA doesn't have a definition of usual and customary.
But the whole purpose of the ADA is to let the market market forces at work, and obviously the market forces aren't working here, are they? Respectfully, Your Honor, we completely disagree. So the only two courts that have There's price competition in this market?
Absolutely. So there's only two courts that have had a full economic record because both of the courts allowed discovery to take place before deciding the legal issue and then ultimately decided the legal issue. But those courts have recognized, with economists testifying, that there is price competition. It's different than price competition that might exist in the commercial airline space, but it's still price competition. And let me explain why. There are more than one air ambulance provider in this state. There are more than one in the regions of this state. As this state has said by the DOT in Kansas in 2017, they have a desire to make sure residents in rural areas with county hospitals shutting down have access to air ambulances, and said that on average, county hospitals are using an air ambulance twice a month, and to them that's enough. And the governor of the state in 2018 said, we really want to make sure, because of the limited number of Trauma 1 and Trauma 2 centers, that air ambulances are accessible to the vast majority, and I think 94% of the population. So what does that mean? That means air ambulances come in. They get the emergency transports, which this is not about normal transports. This is only emergency transports, right? They happen in two ways. They happen on the job injury, an accident on the side of the road, and EMS shows up or fire shows up and says, hey, we've got to transport this person. That's the only way they're going to survive. Or they happen in a hospital. And I'll give you a couple of examples. One would be a stroke. If you want to reverse that stroke, you better get them to a place that can do it in an hour. If you have a trauma, the golden hour, you need to get them there in an hour. So here's what happens. More than one air ambulance company tries to set up a base in that area. They go compete for the hospitals and EMS to call them. What does that mean? Hospitals and EMS and others actually care about price competition. It drives down. We have example after example where we've been driven out of markets by somebody coming in with a lower rate. There might be a hospital that actually has an air ambulance and can subsidize the cost of that.
Is that true in the smaller market of air ambulance services delivered to injured workers?
It is, Your Honor. So from our perspective, there's no difference. And here's why. The Kansas law requires us to pick up, and even federal law arguably requires us to pick up a patient without doing what we would refer to as a wallet biopsy.
Right.
We have no
But
ability
at the
to
end
check.
of the day, are you essentially collecting? In other words, does your bill get written down
No.
for for people who receive the services, but you don't have the option of pursuing a workers' comp claim?
It does not. And here's why. So 60% of our transports are Medicare, Medicaid. And of course, they're done well below cost. We're not making anywhere near what it actually costs us to lift up the helicopter and go there, right? But the rest, so the remaining 40%, that's going to be made up, very small percentage workers' comp, but a much larger percentage commercial insurance. Are there some
It's like the wreck on the side of the road, or
That's right.
or the stroke victim, or what have you.
That's right. Now,
Well,
some
commercial insurance is, don't they negotiate prices with you as well as like they do the doctors and the hospitals?
Absolutely not. And here's why. Because they don't have an incentive to send us any work, right? So when they negotiate with a hospital, they're saying, hey, we're going to negotiate a cheaper price, but we're going to send all of our patients that are under your insurance to you. So insurance isn't coming. But I think the most important point to your question, Your Honor, is this, and I think it'll address both of you. And that is well over 50% of those commercial insurers are still paying full bill charge, because they see the value in the service that's being provided. And if you actually looked at our cost and you weigh it and you see what kind of profits we're making, we're not making profits.
Are you suggesting that your argument is the market's working, and it seems to me that a necessary part of that is the reason insurance carriers are not negotiating for lower prices is that they would lose the service. Is that essentially, you're saying the market has reached the proper equilibrium, and that actually the services can't be delivered
At a cheaper
at a
price.
lower cost.
Yeah, there's three major air ambulance providers: PHI, Air Methods, and Eagle Med's parent, GMR. And one of those recently filed bankruptcy. So yes, we are saying we've reached a saturation point. But I just want to make sure something's clear here. And that is, we're not saying that there aren't issues in the industry. We're also not saying that there shouldn't be somebody that's giving oversight to this industry. There should be, and it's the DOT. And I want to just take a step back and make sure this court's aware of what happened in 2018. Congress created and passed the FAA Reauthorization Act of 2018. And in that, they evaluated changing the preemption provision. They chose not to. And instead, they make it absolutely clear that air ambulances are covered under the preemption provision, and that the DOT has all authority related to unfair, deceptive, monopolistic powers in any form. And so it made it clear, but it took another step. It said, look, we hear all the complaints. We hear workers' comp insurers complaining. We hear state insurance commissioners complaining. We hear people complaining. We want to make sure that this industry is handled appropriately. So Congress said, DOT, Secretary of Transportation, you need to start a committee immediately. It needs to have a workers' comp insurer. The largest workers' compensation insurer in Utah is on the committee. It needs to have a commissioner of insurance. The North Dakota Commissioner of Insurance is on the committee. It needs to have representatives of the air ambulance industry. It needs to have representatives of the commercial insurance on it. And it most importantly needs to have, in addition, a representative from the Secretary of Health and Human Services, CMS, Medicare. The reason is that all of these things go together to create the economics around this industry. Ultimately, this committee is supposed to make recommendations that the DOT comes back and makes to Congress about ways to fix this, not taking it here in a state and trying to have single regulators, which is what the Supreme Court talked about in Morales, Wolins, and Ginsburg, is the solution when the federal government has come in and said it's going to preempt something.
So what's wrong with the Court of Appeals result?
So it takes us out of workers' comp. And so it turns the Workers' Compensation Act on its head. It means that we would have to look to the employee, and the employee would then have to look to the employer in tort liability. So it completely takes it out. And if you look at this court's analysis...
Does it have to be in tort liability? Couldn't it just be in some type of a services rendered? I mean, you keep talking about tort liability, and I understand but does it have to be there?
So I guess they could go talk to the employer, but if the employer said, no, I'm not going to
I'm talking about
play.
the cause of action. I'm sorry.
Yeah, I don't think there is another cause of action that the employee would have to go against the employer other than you're responsible for my injury. And so if you look at this court's severability analysis and how you do it, you ask yourself the question, would the Kansas legislature pass the act as we say it should be severed? Now, keeping in mind for just a moment that there's another solution, which is the 2012 fee schedule. But looking at severability, you ask the question, would the Kansas legislature have passed the act as we say it should be drafted, meaning what we said should be struck out? And the answer is clearly yes. And we know that for three reasons. The first is that there's a severability clause in the act itself. But the second, and I think this is the most telling, at 44501BA, this is under the legislative intent of the act itself. So this is the legislature saying this is what we want. It says, it is the intent of the legislature that Workers' Compensation Act shall be liberally construed only for the purpose of bringing the employers and the employees within the provisions of the act. The Court of Appeals opinion takes us out from underneath the act, takes the employee out from underneath the act, takes the employer out from underneath the act.
As I asked your opposing counsel, there would be nothing wrong. I mean, there might be something wrong policy-wise, but there would be nothing wrong legally if the Kansas legislature did that.
Absolutely not. You're right.
You're just arguing that the courts should not do that.
That's right. And that's exactly what the Wyoming Supreme Court said too. So if Wyoming wants to go in after the fact, change the law and says air ambulances are out of workers' comp, you're going to have to go a different way. Absolutely, that would be feasible. That's not this court's job, which is this court's job is to look at the current act as it currently sits and say, how do we move forward under it? And the Kansas legislature can later make a different decision. Now, I want to address your question, Your Honor, and that is you asked right at the very beginning about whether or not we voluntarily come in to Kansas, and therefore we just subject ourselves to a reasonableness analysis. The Supreme Court answered this question completely and clearly in the Ginsburg case. In Ginsburg, the common law duty of good faith and fair dealing could not be added to a contract. So in Minnesota had a common law duty of good faith and fair dealing that automatically got added to every contract. Despite the fact that the air carrier added a Minnesota choice of law provision, the Supreme Court said, no. You can't add a state policy judgment in an area that's been preempted and adding in the duty of good faith and fair dealing. The idea that we wouldn't be here because we would then be subjecting ourselves to go around federal preemption and not have a single regulator would do exactly what the Kansas DOT was worried about in 2017, exactly what the governor was worried about in 2018, and it would start to take away air ambulances in a state that doesn't have that many Trauma 1 and Trauma 2 centers.
Travelers believes your bill on any one of these cases is excessive. And you want the workers' comp laws to require them to pay. What avenue do they have to dispute the bill you're trying to collect?
To the DOT, Your Honor.
And how would that work?
So they have two ways. Okay, the committee that I just described just a second ago is active. You could watch 6.5 hours of the committee conversation that actually took place last week for 2 solid days.
I'm not going to do that.
Okay.
How does it work?
So the Texas Workers' Compensation Division just wrote a 20-page white paper to that committee that said, here's some things that we would like to see changed about the way this works.
How does that help the insurance company get a reduced bill, though?
So there's a representative of the insurance company as a whole on the committee. So that's working out the problem as a whole. So now the question becomes, what about in individual cases? Right. Well, the DOT has a complaint hotline that you can call, number one. Number two, they have a website where you can submit complaints. If Travelers is able to establish in the DOT's mind that we're being unfair, deceptive, or using monopolistic power, the DOT has full authority to take whatever action Travelers would like them to take related to this.
But how does that slow down the collection of the bill you're trying to collect? It seems to me you're trying to put on them a show, in order to fight this one claim that you want our law to enforce, that you're requiring them to go show some kind of systematic air piracy kind of thing.
We are saying that, because without that, we fully believe, and we think the case law has established it, there's 19 opinions in this space with air ambulances, 7 of them in the workers' comp context, that says that's the free market principles should take hold and should decide the rate. And if that's not happening, then it's the DOT to fix. And so I see that I'm out of time. We do ask this court to vacate the Court of Appeals opinion, remand, and most importantly, reinstate the Workers' Compensation Appeals Board's order that got it right the first time.
So you're not wanting this court to enforce anything, you're simply wanting us to back out.
We're wanting the Workers' Compensation Board to do what it did originally, which it ordered full bill charges to be paid.
I understand your legal argument about preemption and how the Court of Appeals, severability, and how the Court of Appeals did that wrong. But as a policy matter, why do you care if you're taken out of the workers' comp? I mean, your whole argument is we charge the same no matter what, the market forces are working, workers' comp cases are only a small percentage of the services we provide anyway. Why does it matter?
So there's 2 reasons it matters. The first reason is that we do want to take the patient out of the middle. This system, this healthcare system that we have set up, has got insurance in various forms. Some commercial insurance, some workers' compensation insurance. In our perfect world, the patient would be taken out and they wouldn't have to be worrying about this in any form or fashion. In the emergency context, that's been an issue for our medical care system for a very long time. The second is that without the workers' compensation system set in place, I don't believe that we have any clear remedy towards Travelers. So our remedy would be
in this case, but I'm talking about prospectively going forward. If workers' injuries were treated just like those roadside accidents and stroke victims, et cetera, that we talked about earlier, why would you have a problem with that?
Well, so if it was outside of workers' comp, there would be a very good chance that the employees' commercial insurance would have an obligation to cover too. And so there could be a way outside of the system as a whole where we could recover. But we believe that the state of Kansas, and we don't believe the legislature would actually change the law, we believe the state of Kansas would actually want to protect the employer and want to ensure that the employee and that the employer would not have any tort liability. Thank you, Your Honor.
Thank you. Mr. Tinsley, you reserve 3 minutes.
Thank you. May it please the court, counsel. Just a few quick points. That in first, the exorbitant prices, that is a significant issue. And from what I've heard, from what we've read, there's not a free market principle. And what I just heard was 60% of their flights are for Medicare or that they lose money on. And it's difficult to reconcile with this court's language from Martinez that says, we hold that an amount which a healthcare provider has in advance agreed to accept in full satisfaction for services rendered to a plaintiff is the measure of the reasonable value of medical care and expenses for the treatment of the plaintiff's injuries. Obviously that applied to collateral source, but what it stands for is that if you take a Medicare payment, that's reasonable. Here we're talking about apparently an industry built on the backs of workers' compensation, where the workers' compensation charges are 5, 6, 8 times of what a reasonable Medicare value is. That just can't be right. The 2 remedies that counsel asked you for, severability, and compares this to the Wyoming Air Methods case, or Eagle Med case. Wyoming is a monopolistic state. It's a state with no insurance carriers. That's a state-run remedy. And what's happened there is when you deal with the state, whether you settle a case, you're dealing with the state. There aren't third parties involved. It's a different statute. It doesn't comport well with Kansas. We don't think the severability argument applies to Kansas, to the fee schedule statute 44510I. Their alternative remedy is, well, this is the 2012 fee schedule, let it apply because it says apply the usual and customary. For Eagle Med, that means what we charge is usual and customary. In fact, 44508 defines both of those terms so that you compare it to a market. And Eagle Med's opposed to that. But again, that would require some sort of inquiry, again, which is all we're asking for here. More significantly there is in the Court of Appeals, for example, Eagle Med objected to a second request for extension, and the reason was because this was taking too long and there were other cases out there that needed to be decided. One of them was an Eagle Med case that we asked to be included with this early on because it fell under the 2014 fee schedule, which is different than usual and customary. It says you take an air ambulance fee and reduce 10% off of it. So you don't have that remedy today to say we're going to adopt the 2012 fee schedule because others are out there and others are different. So we don't believe that remedy exists. Again, what we're asking for the court to do today is either to reverse and vacate the Court of Appeals and allow some sort of an inquiry to this inequitable system. But if not, then let's affirm the Court of Appeals and we move on.
If you're asking that the commissioner, the director have no authority to order you to pay their bill.
Correct.
And if that's, and I guess the fallback remedy for them is a breach of a contract action against the patient, which is what normally happens when a provider has a bill for a medical provider.
Judge McEnany, that's correct. And again, I don't think that's a tort liabilities counsel.
No,
It would be a contract claim.
Yeah. So, but in that situation, then the injured worker, who would presumably have may or may not have his own insurance, health insurance, if he had a judgment against him for a medical expense like that, and if there's no remedy in comp, then that would go against, he would make a claim against his own insurance company, which would not be you, it would be his private health insurance carrier.
Yeah, which that's true, and that's not really satisfactory.
It isn't, because then we have a separate. We have the typical health and accident insurance coverage subsidizing the work comp system, which is not the way it was designed to do.
No,
so that's not going to work, is it?
No, and I agree. That's not a good result. And so, really, to clarify, what we're asking first is to reverse and vacate the Court of Appeals judgment to allow some sort of an assessment here. And even if it's looking at usual and customary as compared to other providers, if there's been some analysis and then the workers' compensation court says, hey, this is what you owe, then that's fine. But let's put some piece of the puzzle in there that says this just can't be right. This is conduct that's burdening the employers in Kansas, and that's not right. I mean, it's clear from what counsel said, if 60% of their business is losing money for them, then they're making it on workers' compensation. And again, that's not right. We oppose that.
And Minnesota, I take it, viewed, in the Minnesota case, they viewed the notion of good faith and fair dealing as somehow a statutory provision, as opposed to the common law notion of what's implied in every contract.
Right.
Which seems a little strange to me, but that's okay. That's what they say. The notion of a fair and reasonable amount for your services being the measure of your damages in a contract action like this, when the health insurer, when the patient's sued by the healthcare provider, that would be isn't that pretty much a common law, generally accepted principle that could be imposed upon the air carrier, contrary to what happened in the Minnesota case?
The good faith and fair dealing.
Yeah.
Yeah,
It's
it-
not, yeah.
Yeah, and that makes sense to me, Judge. I mean, and again, that's where I struggle with the opposition to the, the ADA federal preemption is the gorilla in the room here, and the air ambulances are kind of beat the drum of, we'll fight this battle everywhere, and I understand that from their perspective, but it doesn't change the fact that it's hard to reconcile that with notions of common law that, gee, we should have good faith and fair dealing in a contract, and we should have some ability to determine what's reasonable, and we should have an ability to determine that if we're making a success of a business just on the backs of Kansas employers, that's not right either. So again, it's a difficult case from that perspective, and it's a whimsical irony to me that your last couple of cases have dealt with the work comp fee schedule of all things, and again, here we are today. So
Well, I think for all medical cases, in a doctor suing a patient, standard I always thought was reasonable and necessary. So the notion of reasonableness is going to come in should apply across the board, shouldn't it?
Sure, and well, that's where in Martinez, again, that's, it says a Medicare, if you're accepting that, that is reasonable.
But
And
their
if that's
argument is that the committee's already doing that.
Pardon me?
Their argument is that the committee's already doing that, isn't it?
Well, it may be. I'm not sure that I've seen anything the committee's done, but that's an argument.
But that is their argument, isn't
Well,
it?
it is, but is that giving us any remedy here in Kansas? No, it's not. And if we follow Mr. Fox's recommendation and we file a complaint with the DOT on these, we're 6 years down the road to here. Do you think that's going to have to change anytime soon? I don't, and I don't know, but I'm just betting that we don't have much of a remedy with the DOT in any kind of the near future either. So it's a challenge. I understand that. These are conflicting principles here, and just the notions of equity and what's fair, that lands on our side, I think. So I'll answer any other questions. Otherwise, thank you very much for your time.
Thank you. Thank you to both of you for your arguments in this matter. We will now take this case under advisement.